Happy Halloween, everybody. Welcome to our noontime spooky situations seminar. My name is June Fan, and I know that back in summertime, you had joined both myself and Daven to hear about our journeys as law firm owners. And now that, it is Halloween, and also Day of the Dead coming up, we wanted to share some spooky situations that could happen to an immigrant. And we've come up with 4 scenarios that are basically, real life situations that could potentially happen to an immigrant. And the journey documents basically the entire journey of an immigrant from being an undocumented immigrant to a permanent resident. So rather than doing lecture style, we're going to do it more of conversational scenario type of discussion with you. So our goal for today's seminar is to basically provide you tips on how to avoid the legal nightmares as an immigrant. So we'll be providing estate planning and immigration tips. And so
Great.
I guess, yeah, we can start off with maybe some introductions. David, would you like to introduce yourself first?
Sure, I would love that. Thank you, June. So my name is Daven Ghandi. First of all, I want to wish everyone also a happy Diwali for everyone who is celebrating. It's the celebration of good over evil, light over darkness. So happy Diwali. I am in my traditional Indian outfit and I just came back from the temple.
Yay.
So a bit of an introduction. My name is Daven Ghandi. I am the owner of Kaza Law. We are an immigration law firm. And I, as an immigrant myself, my goal is to help my fellow immigrants achieve their American dream. So I am very excited to put this panel, this webinar together with June as we go over spooky situations that really come up pretty often, and these are real life scenarios. So I am looking forward to this webinar, and I'm pretty sure we're gonna get through a lot, and hopefully you're gonna be able to receive lots of tips as well on how to navigate these scenarios if it happens.
Wonderful. Thank you, David. And to introduce myself, my name is June Fan, and I am the owner and founding attorney of Gift of Love Legal. We are an estate planning law firm here in Washington, D.C. We serve individuals and families in Washington, D.C. and Maryland. And I'm also Chinese Mandarin speaking. So yeah, we're excited about this webinar today. Shall we dive right in, David?
That sounds wonderful. Janelle, can we get to the first slide, please? To the first spooky situation. So the first situation deals with a temporary visa holder. We have Rajesh. Rajesh is an Indian immigrant. He is on an H-1B visa. Now, the H-1B visa is a temporary work visa that allows somebody to be in the United States for up to 6 years. Now, sometimes there is a backlog for certain countries. And so in this case, India being one of them, Rajesh is from India, so there is a green card backlog. And so his green card is pending, but he's not going to be able to get the green card because there are no available visas for at least the next 10 years. So the situation is Rajesh is on an H-1B visa. He's working as a software engineer in California. He has 2 US citizen children and he owns a home. Now, because of this green card backlog, he's not going to be able to get his green card for at least another 10 years. Now, Rajesh assumes that if anything happens to him, his family will be able to manage, and so he really hasn't created any legal documents to safeguard or protect his family or his estate or his legacy. June, let's dive into your thoughts as you look at this scenario first.
Yeah, if we could maybe move on to the next slide. So first of all, Rajesh is here on an H-1B visa, which wouldn't affect, whether he should create any type of estate planning documents, because most importantly, estate planning documents are based on where the person lives and intends to stay. So given that Rajesh, lives in California, works in California, has 2 children, raising his 2 children in California, owns a home in California, that shows that he intends to stay in California, at least for hopefully, the next couple of years, right? Just as a disclaimer, because I am not a California licensed attorney, so what information that I'll be providing today is going to be general. And if there are any, specific California related questions or specific state related questions, my recommendation would be to consult an estate planning attorney that is licensed in your particular state of residence. So back to this scenario, we have Rajesh, who is living in California. He's got 2 children. We don't know if the children are adults or young children, but if let's just say that, his children's aren't 18 years old yet, they're maybe, let's say, 5 and 6 years old. Well, the first thing that I came to mind when I saw this scenario, the fact that he's got 2 children, is, well, what's going to happen if he dies unexpectedly in a car crash, or something happens in a plane crash or something? What's going to happen to his 2 young children? So what's going to happen is, if he doesn't have any planning done, then the court will come to play. The California probate court will come into play, and basically a judge who may or may not know Rajesh and his family dynamics will likely come in and make a decision and pick someone to take care of his 2 young children. And this person that the judge picks will be named as the guardian for the children. Now, again, the judge will look at a list of factors to determine who to name. But this person that the judge names may not be the person that Rajesh really wants to raise his 2 children, right? So that's why it's important. If you have young children and you love your children, right, then at least think about that. Even if you don't think about, okay, I don't care what's going to happen to me, but I want my children to be in, the hands and home of people I love, or someone that I want to raise them long term, get the planning done in place. The second thing that came to mind was about the home. Okay, so what's going to happen to the home if he dies, right? Now, we don't know if, the fact didn't give us about, Rajesh, about the, whether Rajesh is married, how the home is titled. But those are things that, as an estate planning attorney, when someone dies or someone gets into a car accident and is in a coma for an extended period of time, those are some things that we look into. We look into what kind of assets this person has. If the person has a home and the person dies, how is the home titled? Is there a joint owner? Does the joint owner have the right to this home if the other joint owner dies? So those are some things that we will look into.
I
Yeah.
see. June, what if Rajesh is fired? So generally, when an H-1B visa holder is fired,
Mhm.
they have a grace period of about 60 days, before which they have to either get another visa status, or they have to leave the country. Find another job, get another visa status, or they have to leave the country.
Mm,
Otherwise, they become undocumented.
yeah.
What can he do if, say, he's laid off and he has to leave the country and he's not able to find a job?
Yeah, that's a really good question. So if we could go to the next slide, please. And we do have our mighty Janelle here on in the back, helping us with everything. So thank you for that, Janelle. So to answer your question, Daven, oh, actually the one before that.
So the
Thank you,
previous slide.
Janelle. So what I would recommend, to answer your question earlier, the fact that if he does get fired or laid off and he has to go back to his country, well, again, what's going to happen to his children? So something to differentiate and to something to point out is, even if you have a will in place, the will doesn't come into play until after the person dies. So even if the will names a guardian to take care of your children, after you die, or after, if there are two parents involved, both parents die, um, we have to think about this kind of situation, right? Where he's out of the country for, maybe 45 days, 60 days or so. Well, we want to make sure the children are continuing to go to school, right? Or the children are continuing with their daily lives where they don't have to move around, right? With Rajesh because of his employment situation. So, something that we do at our firm, Gift of Love Legal, is we also help our clients think of short-term guardians for situations like this. Or another example is, let's say Rajesh gets into a car accident. Well, his young children are at home with the babysitter. Okay, well, what's going to happen, during the time period where Rajesh is in the emergency room getting operated for the next 10, 12 hours, maybe in a coma for the next 2 weeks? Is the babysitter gonna, stay with the kids for the next 2 weeks? So coming up with short-term guardians will be helpful too, because short-term
Mm.
guardians are people who can show up at your front door, hopefully within the next hour, if an emergency does come up. So that's something to also take into consideration. And then also having a power of attorney in place too. We hear that term thrown around a lot. What is it really? It's basically a document where you name someone to step into your shoes to take care of your financial affairs, help you pay your bills, help you pay your mortgage, help you file your tax return, go to the bank for you. I mean, do little things for you that you do normally on your regular basis. But because you're in a situation where you're either in the hospital, or like Rajesh, if he ends up having to go back to his country, right, until his visa gets reinstated, or unless he finds another job, well, at least during that 60-day period, there's still someone who can step in, make sure that the kids are fed, the kids are taken to school, and that the bills are paid, the lights are on, and so forth.
Mm,
Yeah.
yeah, and I feel like that's really important, especially if, say, for example, the kids are going to remain in the United States. Then, and Rajesh say he's not able to get another visa, but he wants the kids to be educated here. Having a guardian in place, at least till the child is 18 or 21, is very important. Now, this is especially so because once the child turns 21 years old and they are a US citizen, they'll be able to then petition for Rajesh as a child, a US citizen child petitioning for their parent, and Rajesh will be able to
Oh,
come back in as a green card holder. So even if Rajesh has to leave and he wants the kids to be in America, have in the United States, having a guardianship or a custody or having that in place is going to be very important to make sure that the kids are taken care
I love that. I love that. We're problem solving here. I love it.
of.
Yeah, yeah. And speaking of that, so I mentioned earlier about a will that comes into play after someone dies. And then I mentioned the power of attorney, which is only effective while the person is alive. And there's another document that could help Rajesh too, which is kind of a combination of the power of attorney and the will, and it's actually a trust. And what the trust does is it works while the person is alive and after death. So if Rajesh created a trust, and given the example that you gave earlier, that he wants his children to, continue their education in the US, even if he ends up having to go back to India long term, right? Well, then if he had a trust in place, he could basically give instructions in the trust on how he wants, the money in the trust to maybe pay for the child's college education, to pay for the child's living, but he'll name someone who's going to be in charge of that trust. So that is also another idea too, to
Mm.
have that smooth transition.
June, so before we move on to the next scenario, which we are
Mhm.
already on that slide, I do want to ask you, I think a lot of times as immigrants, or even for me when I came into the country, I'm like, when really should I start creating my will, my estate planning, my trust? The answer really, I think, just based on what you say, is there really isn't a bad time. Because I would think I need to, well, make enough money. I need to make sure I have a house. I need to make sure I have like a good enough fortune that I can then give to somebody else. But then that's not the only consideration, especially if you have children.
Yes, yes. You raised two really good points. Number one, especially if you have children, because now you're not only responsible for your own life, you're also responsible, especially if they're young children, right? You're also responsible for your children's lives, so other people's lives. The second thing that you mentioned is at what point, right? And it's very common for people to think, oh, I have to, have a certain number of assets or a certain amount, of assets to start doing an estate planning. The real answer is as long as you're 18, you can make your own decision. At
Mm,
least in the state that, DC, where I live, right? I think in most states in the US, once you hit 18, you're considered as an adult. So you can make your own medical decision, you can make your own financial decision, right? And so what that means is the bare minimum, at least have a power of attorney in place. In
yeah.
case you're riding the bike and you get hit by a bus and you're in a coma or you're in a long-term accident and you can't pay your bills, you can name somebody to come in and pay your bills for you, even if it's your parents, right?
Yeah.
But if you don't have that in place, then again, like how I explained earlier, the court will come into place and name somebody for you. Sometimes they may name someone that you want, but sometimes they may not. So a power of attorney and then a medical directive, right? Let's say, a 16-year-old or I'm sorry, an 18-year-old rides the bike down, right? And then gets hit by a bus and now is in a coma and can't make medical decisions, but the surgeons have to perform surgery on this 18-year-old. Well, what's going to happen? So those are the two bare minimums to have, I would
Okay.
say. Yeah.
Great, thank you. I have a question, but I would like you to answer this question after we go over the next scenario, which is,
Oh.
does somebody's immigration status come into play? Do you, no, Janelle, let's stay on that same scenario. Yeah. Does somebody's immigration status come into play in that do they need certain immigration documents or status before they can create these documents or before they can
Mm-hmm.
plan for their estate? All right, right?
Mm-hmm.
So let's go to the second scenario, which is the undocumented immigrant. And this affects millions of people currently in the United States,
Mm-hmm.
especially undocumented immigrants with US citizen children. So, for
Mm.
example, the example that we have is we have Maria. She's an undocumented immigrant working as a housekeeper, and she sends money to her family in Mexico. She's also living with her US citizen partner, but they are not married legally. And Maria also has two young US citizen children. And for her, this is a real fear for a lot of undocumented immigrants is to go to any kind of legal authority, right? So she's afraid to create documents or legal documents because she's afraid that she might be exposed to immigration authorities. So
Mm-hmm.
that being said, before you give me your thoughts on this scenario, could you also talk about the immigration status of a person, whether that comes into play if they want to create an estate, a plan for their estate?
Sure. Yeah, that's a really good question. And as you mentioned, since it affects so many people living in this country right now, I think it's important to let people know that it doesn't matter, what your immigration status is. Like I mentioned earlier, right? If you are living in, let's say, DC or New York or California, and you have plans on staying, right? And there are ways to show your intention of staying long term in this country. Maybe you're holding a job, maybe you're registered, to vote. But if you're, undocumented, maybe, you own certain things, right? Or for instance, in Maria's situation, right, she has a long-term partner. She has a job here in the US. She's got two young US citizen children. That shows somewhat of her intention of staying long-term here. Um, then it doesn't really matter what a person's immigration status is. You can prepare these estate planning documents. Yeah, yeah. So I think the short answer is doesn't matter what your immigration status is, you can still prepare estate planning documents. Yeah.
Great. Great. Now, just based on this scenario, can you tell me a few things, just what would happen if something happens to Maria?
Definitely. So the first thing that came to mind when I saw this scenario is she has a partner. Doesn't matter what, you know, uh, status on immigration her partner is, but the fact that they are not legally married. So the first thing that popped to me is, well, she's got a, partner. They probably, had the two young children together, right? Just assuming she and her partner had these two young children together. Well, the fact that they're not legally married, first thing is this partner will not have any inheritance rights if Maria dies. And also, this partner will not be able to make medical decisions if it came to that.
Mm,
And so that's something that's very important to know.
right.
Um, And the second thing that mentioned about these two young children, so kind of back to our first scenario, right, with Rajesh, where the two young children, no naming guardians, short term, long term. So same thing. Yeah.
So if you were to lay out a plan for Maria, what would that constitute? Or what would you advise her to do?
Yeah, I would say, given the fact that, well, first of all, I would want to know whether the young children's parents are both her and the partner.
Let's assume it is. Mhm.
Okay. And then I would make it known to Maria and the partner that because you're not legally married, if anything happens to Maria, this partner really doesn't have any rights to, say no to certain surgeries, say no to certain medications, because this partner knows that Maria, wouldn't want that. But because Maria is unconscious and this partner does not have the right as a spouse or is not named in a medical directive to make the decision for Maria, unfortunately, the partner won't be able to speak for Maria. And so I would make it known to Maria and the partner that this situation could happen. And then let's say if Maria dies, um, and let's say, all the hard-earned money that Maria has been making and saving to send her to her family, and the partner knows that this is what Maria would want to do. But the fact that because there is nothing written, right? And Maria is not married to this partner, well, unfortunately, we can't really follow those wishes. Um,
Okay.
yeah,
And
yeah.
then, Janelle, can we go to the next slide, please? I realize we were. All right, great. Now, on the immigration end, if Maria is detained or she's deported, and I'm talking about a third point here,
Mhm.
will her partner or children have access to her money? What happens to, say, her savings or any of her financial documents?
Yeah. So, first of all, if Maria has, let's say, bank account, for example, right here, the example says bank accounts or savings. Even if Maria doesn't have any planning done, no will, no, healthcare directive or power of attorney in place, um, I think the bare minimum for what Maria can do in this situation, if she has her bank accounts and so forth, she can name her long-term partner as one of the beneficiaries on a pay on death form
Mm,
through the bank. So most financial institutions will have a pay on death form to the account holder. Now, one caveat is because Maria has young children, we wouldn't recommend Maria naming her young children as a beneficiary because, minors can't technically receive the assets given to them until they're considered as adults. So if let's say Maria, follows our advice, goes to her bank and completes the pay on death form and she names her partner as the first beneficiary, but then somehow the partner ends up dying before she does, and her young children are named as the second beneficiaries, Well, sadly, because the young children are not minors yet, what's going to happen is those funds will end up again. The court comes into play, names somebody to manage the funds for the young children, and then once the young children hit age 18 or hit the age of majority, they end up receiving the whole lump sum of whatever was, given to the young children. And that could be an issue too, right? For most
Yeah.
parents, imagining their 18-year-old inheriting however much money, right? I mean, I've seen it personally, right? Especially if they haven't been educated or trained about money management, those type of skills, or been educated on that could, um, you know, play a role in
Okay.
what could happen. Yeah.
Now, on the immigration end, if Maria came to me as a client and I have a lot of undocumented clients, the first thing I would also inquire is why is she not married to a US citizen partner?
Mm.
Maybe he's still technically legally married to an ex-partner, and they just haven't divorced completely.
Oh.
But whatever it is, I do want to find out why she's not married to her US citizen partner, because on the immigration end, if Maria really the question lies in whether Maria entered the country legally with a visa or she came in without documents. Because it's also possible for somebody to come into the country with a visa, for example, and then they overstay their visa.
Mm-hmm.
And when they overstay, they become undocumented. If that's
Mm.
the case, right? If just say she overstayed her visa and she became undocumented, if she's married to a US citizen partner, her US citizen spouse can then petition for Maria without Maria having to leave the country. So that will cure her unlawful status, her unlawful presence in the United States. Similarly, Maria has two US citizen children. When they are 21 years old, they could also petition for Maria. And because Maria had that first legal entry, any unlawful presence is forgiven because her US citizen children is applying for her. They are applying for her visa, her green
Mm.
card. Now, on the other hand, if Maria came in without documents, so she came in undocumented,
Mm-hmm.
then her children are not going to be able to apply for the green card for her. She would need a US citizen spouse. Or if I'm being really technical, the children can apply for a family visa for her. But Maria would need a waiver because of her unlawful entry. And
Mm.
this waiver depends on the hardship to only a US citizen or green card holder spouse or parent. They don't consider the hardship to the children. So in this case, if she has a US citizen spouse, then the hardship could be based on the spouse if she were deported. So that would be the
Oh.
basis for the waiver. And so again, if Maria was my client, I would ask why she isn't married to her US citizen partner, and then give her the options of what could be the solution if she came in legally, and that her children can then petition for her in the future.
Mm-hmm. Mm-hmm. I
Yeah.
love it. Wow. I love it. I'm learning. I'm learning from you, Daven.
I'm learning from you too, June. All right, so now let's go on to the next scenario. And I think this next scenario might apply to a lot of people here. Um, which is having an immigrant parent and a US citizen child. So an immigrant parent could also be naturalized immigrants, so naturalized immigrants, meaning they are US citizens, but they do come from a different country. And the example we have is Wei is a Chinese immigrant with limited English proficiency. She owns a small grocery store with her son, who is a US citizen. Wei is reluctant to create documents due to cultural beliefs, and this is really interesting. That discussing death brings bad luck. And I know in Chinese they have the word choi, which means bad luck, right? And so
Yeah.
discussing death, and I think even maybe in the Indian culture as well, that it's not something that we talk about often. And so estate planning, really, you look at all situations, especially if you were to die, right? And so this is not a common practice in Wei's culture. She also has elderly parents in China that she wants to support. Now her son wants to ensure that the business runs smoothly, but is unsure how to plan legally for the future.
Mm.
Thoughts, June?
First thought that came to mind is the fact that Wei owns a grocery store, so she's a business owner. And then the fact that she's got her son, who sounds like is an adult, or let's just assume that her son is an adult. Um, the son wants to ensure that the business runs smoothly, but is unsure on how to plan legally for the future. So first thought that came to mind is Wei as the business owner and the son need to have a conversation, because clearly the son is younger than Wei, and we don't know if the son is going to, continue to run Wei's grocery store after Wei passes away. But the fact that the son wants to ensure that his mom's business runs smoothly after she passes away, um, we need to make sure that Wei and the son have a conversation about what her wishes are, what her plans are for the business, does she want? Does she want the son to take over? Is the son interested in taking over? I think that's a conversation that the family needs to have, or at least between Wei and the son. That's the first thing that came to mind. The second thing that came to mind is once after they've had this conversation, then I would recommend Wei to speak to a business attorney a business law attorney who can basically advise Wei on how to plan for the succession of her grocery store, of her business. And oftentimes, business law attorneys and estate planning attorneys will work hand in hand. Some estate planning attorneys also have business law backgrounds, so they can do, a little bit of both. But that's something that I would recommend. Wei and son to have a conversation about her plans for the business. And then once they've had that conversation, then she should go seek a business law attorney's advice on doing, the business succession planning. And then, of course, estate planning, like what we talked about with both of the scenarios earlier, right? If something happens to her, well, we want to make sure that the son knows what Wei wants with her medical decisions, with her paying the bills, right, including paying the bills for the business, right, and then also after she dies, what's going to happen to the business, what's going to happen to all of Wei's personal belongings and assets. Yeah.
So I have three follow-up questions.
Sure.
Which may sound like a lot, but what about the fact that Wei has limited English proficiency? What would
Mm-hmm.
you advise somebody like Wei to do?
What I would recommend is, I know there are a lot of attorneys out there, including myself, who speak a second language besides English. So what I would recommend is for Wei, and if the son wants to help his mom out, which I've actually seen, children helping their elderly parents out because of limited English proficiency, by seeking out, attorneys who actually speak their parents' native language. Because even what I've experienced and seen is even though the parents speak English, they sometimes feel more comfortable working with a professional, whether it's an attorney or a doctor. I know my parents are like that, right? They speak English, they've been in the US for decades, but they still feel more comfortable working with a doctor that, even if they speak limited Chinese, they prefer to speak with someone who can, who looks like them, but also who can somewhat kind of like speak a little bit of the language.
Yeah,
Yeah.
and I think you are absolutely right that it's not also sometimes just the language, it's also the cultural competency, right? They want to feel
Wow.
connected culturally to this person.
Yeah.
Thank
Yeah.
you
And
for
being
that.
able to, yeah, go ahead. Sorry, David.
Oh no, go ahead, go ahead. I was gonna jump into the next question.
Oh, okay. Thank you. But I was going to add, similar to just like what you mentioned earlier, the cultural competency, who can also kind of understand why Wei is hesitant to discuss death, right? Who knows? Okay, I know what I see where you're coming from, kind of like that. Yeah.
Yeah, yeah,
Mm-hmm.
great. And then the next one is, and it's in the fact pattern, which is she has elderly parents in China that she wants to support.
Mm.
What can she do here to ensure that that continues? Or can she do anything about it, given that the parents are abroad?
What I would recommend is, once Wei and her son have, specifically Wei, once Wei has chosen an attorney, estate planning attorney that she wants to work with, what I would recommend is, having something in writing, whether it's in her will or her trust, basically saying that, I have been giving a certain amount of money or a certain percentage of my money each year or each month, whatever it is. And it is my wish, or Way could even make it mandatory for whoever is managing her assets, for her, for the money to continue to be sent to China to Way's
Mm.
elderly parents. Yeah.
Okay. Then my next question, my last question about this scenario is, if you get Wei and her son as clients, like they came into your office, would you also then advise the son to have his estate planned as well?
Yes. Yeah. Yeah. And um sometimes when working with families, the families plans could kind of work together. So that is one of the beauties of working with multi-generational families.
Mhm.
But yes, if the son is 18 and above, just like what we said earlier, you should at least have the bare minimum, right?
Yeah.
Yeah.
Janelle, can we go to the next slide? So on the immigration end, there's really nothing for me to add to this scenario because they are both US citizens. So they
Mhm.
don't really necessarily need an immigration attorney unless, for example, Wei wants to sponsor her siblings who may be abroad, or if she has other adult children who are living in another country, then she can seek the services of an immigration attorney. Or in her son's situation, if the son were to get married to somebody from China, for example, and he wants to bring his spouse over to the United States, he'll then seek an immigration attorney. But other than that, with that particular situation, the immigration attorney really doesn't play a role, except maybe guide. A lot of times, lots of my clients who are already citizens do come back to me to be like, "Hey, I'm looking for another attorney who can help me with my probate or my estate planning." So then I would guide them towards the attorneys and make that referral. So we discussed the spooky situation already, and I believe we discussed what happens if Wei dies, if the son experiences an event. Let's jump to the last scenario that we have today. Janelle, next slide, please. Thank you. So we have spoken about an individual who is here on a temporary visa, a non-immigrant visa, like a work visa. We've also discussed the situation when an individual is undocumented. And then the last scenario we discussed having a being a US citizen. Now let's focus on lawful permanent residents or green card holders. Now, a green card holder is somebody who is here, who can continue to remain in the United States permanently. They can work, they can travel, they can live. They can also apply to become a US citizen after being a green card holder for 5 years. Or if they are married to a US citizen, they can then apply to be a US citizen themselves or naturalized after 3 years of being married to a US citizen. So in this particular situation, we have the successful LGBTQ green card holder couple with a newborn via surrogacy. Alex and Miguel are a same-sex couple who recently became green card holders. They have both just started their own business. Alex is a graphic designer, Miguel runs a cafe. They also recently welcomed their first child via surrogacy. They are focused on growing their business and raising their child, but they haven't given much thought to estate planning, assuming that their legal status and their joint finances are enough because, hey, I can live here in the United States permanently. There's nothing for me to worry. What would you say to Alex and Miguel if they came to you, June?
Sure. So the first question that I thought of when I saw this scenario was, are Alex and Miguel a married couple?
Let's assume they are a married
Okay.
couple.
Okay. Otherwise, the same thing. If they're not a married couple, then similar to Maria's situation that we had discussed earlier, is then both Alex and Miguel would, even though they're, long-term partners and they have a child together, they would not have inheritance rights. They would not be able to make medical decisions for each other. Um, so the fact that they are a married couple, And they're here as lawful permanent residents. They both have successful businesses that they run. The second thing that came up is they have their first child through surrogacy. So my next thought is, well, are any of Alex or Miguel the actual parent, meaning they used their, either Alex's or Miguel's sperm to create this baby, right? If yes, then okay, the other parent will likely have to adopt this child, right? And so that's the next thing that came to mind, because if either, let's say, for example, in this situation, if Alex we used Alex's sperm for this baby, but Miguel, we didn't use his genes for this baby. Well, then Miguel will have to adopt this
If
baby.
Alex were to die, for example.
Even before Alex dies,
Right, I mean, you want to do
Miguel.
it before, because if he dies, then Miguel might have problems trying to get the baby, uh, trying to get guardianship over the baby, or any kind of not power, legal authority over the baby, correct?
Exactly. Exactly. Yes.
Okay.
Because otherwise, Miguel, if nothing's in on documented in writing, Miguel is really just a stranger who has no relationship with this baby then. When in reality, Miguel and Alex have been raising this child who probably went through, right, various stages to even get this baby born in the first place. So the first thing that I would recommend is to make sure that an adoption is in place so that both Alex and Miguel are named as parents of this baby, so that as parents, they have certain parental rights. So that, for example, like what you said earlier, Daven, if something happens to Alex, Miguel can at least continue to be the quote unquote guardian of this baby. Um, and so that's the first thing that came to mind. And then the second thing that came to mind is their businesses, right? Yes, they have joint finances, right? But they each own their own businesses. So similar to Way's scenario earlier, they would have to make sure that something is discussed between them or with their business partners. And then I would recommend that they see a business law attorney to help them create a plan for the succession of their business. They may want to name each other, to eventually inherit the proceeds from the business or to continue to run the business, but that's up to them to decide how they want to have the business managed. But definitely make sure that something is in place for the businesses.
Okay. Janelle, can we go on to the next slide? And so, yeah, and I think you answered all of these, which was what will happen if one of them dies, what if both of them dies, and there's then, and again, not just the adoption, but then making sure that there is a guardian in place if something were to happen to both of them. And then the last one would be medical or business decisions.
Yes.
And
Yeah.
as far, anything else you'd like to add about this scenario, June?
It's all very similar, to they all kind of come in and tie in together, right? So
Yeah.
the bare minimum, the healthcare directive. I know in New York it's called healthcare proxy. Some states call it medical directive or healthcare power of attorney. They're all the same. So the bare minimum is to have that in place so that in case anything happens to the person, someone they name, someone that they want to step in because that person knows this person's lifestyle and desires and, wishes, can make that decision for them.
Mm.
And then a power of attorney, to help make sure that the bills are continued to be paid and take care of the finances. And then a trust, if that is an appropriate, use of helping, achieve the goal of this person. And then the will to basically instruct. who they want to come take care of their young children, and how they want their assets to be distributed after they die.
Okay. Now, on the immigration end, if Alex and Miguel were my clients, because it seems like one of the reasons why they assume that they don't want to create a will or a trust or a plan for their estate is because they feel like they're comfortable with their immigration situation and also their financial situation.
Mm.
But the thing about being a green card holder is at any given time, it can be taken away. Assuming, for example, if let's just imagine the situation, Alex and Miguel went out to dinner. Alex has a few drinks. He's driving home. He gets pulled over for drunk driving. As an immigrant and a green card holder, he is still subject to immigration laws. So, drunk driving is viewed as a crime of moral turpitude, and if it's a misdemeanor, for example, that could put his green card or his legal permanent residency in jeopardy, meaning
Mm.
that it could still be taken away. He could be referred to immigration court and potentially even be deported. So a green card, as secure as it is not a permanent status. It can be taken away if they commit a crime, for example.
Wow,
So
that's
that's
wow.
something that Alex and Miguel should both know, right? So I would sit with them and plan and be like, hey, this is why it's important to make sure that you have planned your estate and you're working with a good attorney doing that. But then also let's look at when you can qualify to become a US citizen, and let's get that process started, especially now that you yourself have US citizen children and you want to make sure that they are protected if anything were to happen to you.
Yeah, yeah.
And then I guess also the benefits of becoming US citizen is obviously they get to make decisions over themselves. They get to make decisions over the United States, for example, because as we all know, voting is next week, and you can only vote as a US citizen and not a green card holder. So if they want to make a decision that would be helpful towards them as LGBTQ couples, for example, with Alex and Miguel, uh, they need to have their voices heard. And so they can do so by becoming US citizens and then being able to vote. The other
Yeah.
thing that's really important is, for example, if Alex and Miguel are from a country that have laws against LGBTQ individuals, I don't see how they're going to be able to go back home with their surrogate baby and live a life, because they could
Mm.
be arrested, they could be in prison, or worse, right? And then so having a US citizenship will protect them from any possibility of being deported to a country that is anti-LGBTQ.